Hi again, Attorney Steve Vondran here. Welcome to another exciting episode of Litigation Whiteboard. Okay, so we are talking in this video about the federal court Rule 12B as in biscuit, Rule 12B, motion to dismiss. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we go. As you can see, I have my whiteboard already up here ready to go for you. And so this is general legal information only and not legal advice or substitute for legal advice, as you know if you've been watching my videos. But this is a video about what happens when you get into a federal court complaint situation. And this is the opposite of what you may hear in a state court called a demur, okay? But it's essentially the same thing, a motion to dismiss, a demur. But when you're in federal court, don't call it a demur. The judge is probably going to look at you funny and say, "Excuse me, counsel, what? Demur, you mean motion to dismiss." Okay, so let's get into it here. It all starts, as you know, with the federal court complaint. And if you've been watching my videos as one of my good students here, you know that the federal complaint has to have either a federal question or diversity jurisdiction. You know there's limited ways to get into federal court, but let's assume we have a federal copyright complaint. That's a federal issue, right? Arising under the federal United States copyright law. So you file the complaint, you're going to serve it on the other party. You got your summons, your complaint, that all gets served on the other party. They have 21 days in federal court from the time the summons is served to respond, okay? So the response, if you watch my last video on federal court timeline, the response can be either an answer, they can just go ahead and answer the complaint, run down the list, deny, 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 yes, I admit that, deny, deny. Or you can file a Rule 12B motion to dismiss if you have the proper grounds. And I'm going to go over that here in a second for you, the proper grounds. This may come up on a bar exam. You're going to get bonus points. You're going to spot the issue, I should say, when you get into this. So 21 days. So say we're right up to the 21st day. You come in and you say, I'm going to file a motion to dismiss. Okay, what are the proper grounds? There's 7 grounds that I've identified, and they're actually right here. If you go to my website, FRCP12B.com, FRCP12B as in biscuit.com, you will find this listed here for you in case you need it. But I shortened it up, summarized it as I always do to make law more digestible and understandable for you guys. All right, so first one, subject matter jurisdiction. So one might be you're saying the court doesn't have the subject matter jurisdiction to hear this complaint. Okay, so maybe it's a state law case. It doesn't meet the amount in controversy requirement, and somebody's saying, Judge, there's no diversity. Why is this case here? There's no subject matter jurisdiction. Okay, so that may be one ground. So you plead it, you cite your case law in your motion to dismiss, okay? Second one is lack of personal jurisdiction. This may be the case where somebody from California is being sued in a Texas federal court, and they're saying, Judge, I have never stepped foot in Texas. I don't know anything about Texas, except they have a bunch of oil wells. I don't have a website. I'm not selling to customers in Texas. There's no personal jurisdiction, what we call lack of jurisdiction, what some people call want of jurisdiction, okay? So that could be another grounds to file a 12B motion to dismiss. Number 3, improper venue. You can have a complaint filed in Texas in the right court, but it may not be in the right federal court. The defendant may live up in Amarillo, Texas, and it's being filed down in Corpus Christi. Hope I have my geography right for you Texas peeps. But you say improper venue, so you want it to be transferred to another venue which would be better suited, okay? So improper venue, I think they call that from law school, forums, non-venue, venue, non-forum, I forget the term, but lack of venue or improper venue will probably be sufficient. Improper process, the process serving the complaint is improper, and this just ties in right here with number 5, invalid service of process. So you have the process itself being insufficient, not naming the proper parties, other technical errors, or you have invalid service of process. They're sticking it on your car windshield. That's invalid. Okay, so things like that, you may raise a 12B on this. Now, realizing some of these 12B issues, you may be able to address them. You may be able to reach out right here and meet and confer and check your local requirements. Some jurisdictions are going to have that local meet and confer requirement. So you may be able to meet and confer and satisfy some of these issues so you don't have to file a motion, but that's something for you to resolve. So the service of process issue can be another grounds. We have, this is probably the most popular one you see right here. Failure to state a claim upon which relief can be granted. Failure to state a claim upon which relief can be granted. And that may be something, this could be a real good one to test on lawsuit. Somebody brings a totally frivolous lawsuit. They can't meet the elements. They're not even pleading the elements. They're just, it's some really bad, poorly written complaint. You'd meet and confer, file your motion to dismiss for failure to state a claim. It's just not a cognizable claim on its face, okay? And then the final grounds for a 12B motion would be your joinder, Rule 19. That would be a situation where there's another party that's liable. Maybe it's a webmaster in a copyright case. Maybe you sued the end user of the copyright, but you didn't sue the webmaster. Everybody knows it's the webmaster. Well, you may need to join the webmaster in the lawsuit, name them in the lawsuit, or be subject to a Rule 12b-6 motion to dismiss. So again, some of these things can be cured with a meet and confer to avoid the court motion. Remember, courts are busy. They don't necessarily love all these little motions, okay? But you have a right to bring them where the facts fit. So in your motion, you're going to follow your local guidelines on page limits. Some people like to write 100 pages. Okay, there's probably page limits on your motion, what you're going to be able to write. Get your contents in there nicely organized. You're going to write what your issues are. You're going to cite supporting memorandum of points and authorities, your case law, your federal case law that's going to, or state law in some circumstances, to support you in your motion, okay? From there, you file the motion, you've got the court date, the other party gets to oppose. And they're probably going to oppose based on some of the things that were discussed in the meet and confer process, but they're going to oppose. This is your basic motion practice. Motion, opposition, reply, hearing, okay? Motion, opposition, reply, hearing, and the ruling. So the opposition, again, could just dispute the things that are being raised, dispute the facts, dispute the law. You may have declarations. You may have a request for judicial notice. I keep meaning to do a video on that. I'm going to write that down again. And you may have some sort of evidentiary exhibits as well. So at any rate, so you have your motion, the opposition, there's all time frames. There's time frames for these. And then this party, that filed the complaint, gets to reply and say, I don't agree with anything that's being said in the opposition, or I agree with this, but not that. So you're going to have your reply, and then usually you're going to have your tentative ruling by the judge. That's going to tell you the way the judge is usually going to want to rule. Sometimes, like for example, up in Northern District of California, San Francisco area, the judges may say, if you submit on the tentative, let us know, we won't have a hearing. Other times it'll be different. So read your tentative rulings. This will tell you how the judge is feeling about it. You may have a hearing if the parties say, wait a second, judge, you got it wrong. And ultimately, however, you're going to have a ruling. The judge is going to say, motion to dismiss is granted, overruled, sustained, so forth and so on. So what usually happens, I'll say a lot of times, in my experience, a lot of people will bring the motion to dismiss. I brought the motion to dismiss. A lot of times they have merit to it, maybe something technical. You fix it, and the judge, as I point out here, may very well give leave to amend the complaint. Leave to amend the complaint. That means, okay, you got a problem, you got 10 days, amend the complaint, serve it on the other party, and hopefully we don't have to go through all this again. But you could end up going through all this all over again for another such reason. But the judge will normally allow you to amend in the interests of justice, and the right to amend is liberally granted to give the parties their day in court and a chance to state their case if they have one. So this is the general view of what happens when you hear somebody say, I want to file a motion to dismiss. you may end up being successful where they can't amend and they know it, maybe as to one or more causes of action, maybe two of the causes of action in the complaint you challenged, and they just can't amend. They go, yeah, I know it's conversion and I just don't have the facts. I see that one all the time, conversion, and I just don't have the facts for that. Okay, well, you just knocked out the conversion cause of action. Well done. So that's the power of the motion to dismiss. You're trying to limit that complaint. You're trying to knock out a few causes of action or the entire complaint if it's completely frivolous. So there is going to be leave to amend, but only if you can state some facts. And if you're this party, they're filing the motion to dismiss, you're opposing, you're replying, the party seeking leave to amend, you should usually say, yes, Judge, I have facts that I can amend. The other party should be saying, force them to show the facts, Judge. Force them to bring it out at the hearing. Tell us what the facts are. I don't think they have any grounds to amend. And then oftentimes you'll see the judge say, the plaintiff can amend if they can do so, something like that, okay? So that's a quick and dirty overview of the motion to dismiss federal court. In state court, we're calling it a demur, at least in the two states where I practice, California and Arizona. If you need more information, go to FRCP12B.com. B as in biscuit. You're catching on. Okay, so that's it, Attorney Steve. I hope you like this video, this overview. If you like it, please give me some comments. Smash that like button. That always helps me keep me going. And also, don't forget to subscribe to our channel. It's one of the best legal channels out there. I haven't seen any others that are bringing you all this wealth of general legal information. So I hope you enjoy it. Attorney Steve, I got a busy day, got to get running. Take care.